I'm live. I'm live. How about that? I see it right there. All right. So let's see. Where where is it? Okay, I think I've got it. Yes, I do. Yes, I do. Okay. So for anybody that's here, let me see. I'm still struggling a bit on whoa, on seeing comments and whatnot. So, if you do make a comment, just know that I glance down every now and again, but um, I've got a lot of reading to do. I got a lot of sharing. See, I don't know. I'm pretty sure. Whoops, I didn't charge my phone. I'm pretty sure that I said it. Hey, Robbie. Aw, thank you. Dirt in my eye, Deborah. Well, hi, guys. So, I am not real sure if I said it, and y'all let me know if I'm talking too loud. And there may be you may hear noise. This is kind of a busy time at my house, so it's a big house. I mean, it's a full house. So I've got one, two, three, four grandbabies here right now with their mama. She's hopefully gonna make me some coffee soon. Oh, thank you. So I don't I think that I said, see, I'm never going to remember what I say, but I think that I did bring up that I am so irritated with what's being done to Karen Reed. I am even when if this would have ended, if Beverly would have actually done the right thing today, I would have still dug into the history because after the trial, I'm just gobsmacked. I mean, I don't know how to put it any other way. I just find it so hard to believe that this can happen in the United States of America. And I'm mad. I can't do anything about it. I can't be of any help. If I could, I would. So um, I'm going to take information that Turtle Boy has put out. I'm going to take pre motions. I'm going to take anything that I can find, and I'm going to just stick it right out here for people to see. And I'm going to hope that people see it. I'm going to hope somebody somewhere in Massachusetts will do the right thing. And they need to not only take care of Karen Reed, but they need to take care of their citizens. I mean, Karen Reed opened, in my opinion, opened the biggest can of worms I've seen in my life so far of something being just hideously done. So, with that said, um, let's see. Let's see how the Commonwealth was. Let's see if they had anything up their sleeve. So this is from the, is it from or to? Miss Police runs. So this is from the U.S. Department of Justice, and it's dated August 3rd of 2023. Dear Miss Beeland, well, this responds to your, oh, I didn't find that. I didn't see it June 21st, I don't think. But this responds to your June 21st, 2023 letter concerning your putative request for recusal of the United States Attorney's Office for the District of Massachusetts from the pending state criminal matter, Commonwealth versus Karen Reed. As you indicate, the Department of Justice Office of Professional Responsibility, OPR, informs you that they had referred your May 18th 2023 letter to my office for whatever action I deemed appropriate. I don't see that one either. If I'm not mistaken, I think this is the letter that Karen Reed actually put as her profile picture that everybody was talking about. And they get good. I haven't read them all, but uh, these are enlightening to say the least. Consistent with the terms of the referral from the OPR, I contacted Acting United States Attorney Joshua Levy. Based on my understanding from that discussion with the USA, Levy, his office has a very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter. His office has not reached any official determination whether prosecution is warranted, but they believe it's essential to continue their investigation given the information of which they are aware. At this time, we see no basis for a recusal in this investigation. Thank you for your contact information and willingness to provide additional information as needed. Sincerely, J. Macklin, General Counsel. I wish I had those other two. I wish I had those other two emails, and the reason I'm doing this is they're in order backwards. So that's the same one, I think. Nope, nope. Oh, well, duh. Okay, hold on. They're all out of order. So, all right. This one, see, I got to get on here and look a fool, don't I? All right, so we have a June 21st and we have a May 18th. So this one is June 21st. All right. All right, let me write that down so I see them. June 21st. And looking for May also. Okay. All right. So let's see what this one is. The Commonwealth of Massachusetts, Office of the District Attorney for Norfolk District. This is from Mr. Morrissey. Now, we've heard his name a lot, right? All right. So, this is in regards to June 1, 2023, letter from the OPR regarding review of conflict of interest. Dear General Counsel Macklin, this letter is to inquire about the status of a request for a transfer of investigation due to a conflict of interest. On May 18th of 2023, the Office of the Norfolk District Attorney sent the Department of Justice, Office of Professional Responsibility, the OPR, a letter raising concerns as to a potential investigation by the United States Attorney's Office for the District of Massachusetts involving witnesses relating to a pending state criminal matter, Commonwealth versus Karen Reed, and the death of John O'Keefe in Canton, Massachusetts on January 29th, 2022. Might I just point out that even here he doesn't state that John O'Keefe is a Boston police officer? It's okay, Alice. This office has subsequently received a June 1, 2023 letter from Jeffrey R. Ragsdale, counsel for the OPR, reflecting that to the extent that the letter indicated that the pending grand jury investigation should be reassigned, the appropriate office to address that request was the Executive Office for the United States Attorney, the EOUSA. This is to inquire about the status of the request and to provide contact information for any further information you may require. If you have any questions or are looking for any additional information, I may be contacted as set out above. Sincerely, Lynn Beland, First Assistant District Attorney. I think it's pretty easy to say that the Commonwealth did not want the they don't want anybody looking into this, do they? We're just gonna go by these dates for now. I could later I mean, yeah, I'm not gonna hunt them around. This one, well, maybe I will. November 23rd, 2023, October, June, oh, May. Okay, June. Oh my gosh, they just kinda hop around. Let me see. Look at this one, how long it is. That's May 18th. This one, this long one right here, May 18th from, DA office. Let's see what this one, 24th. Okay, so alright, I think I'm sorry, guys. My apologies. I should be a little more organized, right? Dream on, dream on. Yep, one of them. That's the story of my life. Okay, I'm not going too fast, I hope, and, looks like this is gonna be a massively long email right here. Oh my gosh. Michael Morrissey. Let's see what Michael Morrissey sent May 18th of 2023. This is to the Office of Professional Responsibility, U.S. Department of Justice. It's in regards to investigation by the Office of the United States Attorney for the District of Massachusetts. May 18th, 2023. You tell me that this DA's office didn't know there was something smelly going on. And they try everything to get them out of it, didn't they? Let's just check it out. The deeper it goes. Mm-mm-mm. Dear Sir or Madam, I write to formally request that an ongoing investigation being conducted by the United States Attorney's Office for the District of Massachusetts be examined by the Office of Professional Responsibility, and should the investigation continue, that it be transferred to another office without history of conflict, bias, and abuse of prosecutorial discretion as outlined below. Wow, he's got a lot of nerve. Using he's got a lot of nerve because this is from him. Yep, he's got a lot of nerve saying another office, okay, is being like he is. But um, when you're lacking, I guess I guess you just point out anything to anybody, right? The Norfolk District Attorney's Office has undertaken an extensive investigation into the facts and circumstances of the death of John O'Keefe in Canton, Mass. On January 29th, 2022. I want you all to know this is not in the letter, but let me just say you have now been informed that the investigation into John O'Keefe's death actually was extensive, according to Morrissey. Anybody say he needs to be replaced? If he calls this extensive, what's sloppy? I mean, seriously. Okay. All right. The facts and evidence gathered, including more than 40 individuals testifying before the Norfolk County Grand Jury, led to the second-degree murder indictment of Karen Reed. Was the operator of the vehicle that the evidence demonstrates. This is a pure lie. I don't think they had even I mean, had Trooper Paul even said anything by this time? I thought maybe he came up with his explanation the night before trial or something. It was so horrible. But then again, what happened to Trooper Paul, I think, is they said, "This is where everything was found. Karen Reed hit him with a vehicle. You make it happen in your explanation." I mean, that's how I see it because he's the most doofus of anything I've seen. So, let's see. See, I get off. I'm so sorry. This is oh, he did. Oh my goodness, he does refer to him finally here. All right. The facts and evidence gathered, including more than 40 individuals testifying before the Norfolk County grand jury, led to second degree murder, indictment of Karen Reed. Reed was the operator of the vehicle that the evidence demonstrates struck her boyfriend, Boston police officer John O'Keefe. O'Keefe was then left to die in the snow on the side of Fairview Road, Canton, during the evening of January 29th, 2022. The case has been systematically making its way through Norfolk Superior Court with ongoing discovery still active and open, including motions under advisement, and the motions have not been heard. So here I go. I'm going to interrupt again. O'Keefe was then left to die in the snow on the side of Fairview Road, Canton. Is that is that a true statement? Because he wasn't on the side of the road. He died in another Boston police officer's front yard. That's a major difference here, buddy. Major difference. At least in my opinion, that's a major difference because the way you wrote it makes people think that he was hit and then left in the road. You forgot to tell him that the officer was flown a good 30 feet, right? You just left that out and you said die in snow on the side of the road, of Fairview Road. I don't know. Maybe I'm just picking apart where it doesn't need to be picked apart. Or does anybody else think that that is, I mean, misleading? I mean, I find it misleading, but I don't know. I'm not sure. Sassy, knock it off. Knock it off. Go outside. Take it outside, girl. I'm sorry. I have a loudmouth Pomeranian. So usually if I tell her take it outside, she'll go. But when there's somebody in the kitchen, she's afraid they might drop something. So I don't know. I just and that's not fair to be asking questions when really y'all just can stick me in your ear and not even have to use your keyboard. But I don't like that. I don't like that statement because I think it's misleading. All right, back to the email. The defendant, through counsel, has been raising. Oh, my word, my reading is not the best. Specious issues of a third party culprit and complaints of witness and police misconduct as they attempt to confuse by offering not different interpretations of the Commonwealth statements, evidence, and positions, but inventing them out of whole cloth. Talk about the pot calling the kettle. No actual substantiated evidence supporting police misconduct or any federal violations have been identified by the defendant. The district attorney's office or the Mass Superior Court during the ongoing discovery process. See Exhibit A, defendant filings, blah, blah, blah. Maybe we'll find those too. Approximately 3 weeks ago, multiple state witnesses oh, this is why we have the letter, okay? We got it now. He's trying to defend the McAlberts. That's what's going on, y'all. Already. I I hadn't even read but this little sentence, and I can tell you what's coming. Let's start it again. Approximately 3 weeks ago, multiple state witnesses who've been brought before the state grand jury notified the Norfolk District Attorney Office that they were contacted by the FBI and subsequently received subpoenas to appear before a federal grand jury. Shortly after those notifications to the Norfolk District Attorney's Office, Joshua Levy, I hope it's Levy, first assistant in Boston office of the United States Attorney Office, contacted Norfolk first assistant district attorney Lynn Beelan to suggest that they were conducting an investigation that may involve a number of witnesses in the Commonwealth versus Reed murder case. At that time, Attorney Reland expressed some concerns about both the jurisdiction and the timing of the action being taken by the United States Attorney's Office. You notice it's the United States Attorney's Office. So, what we have is the Commonwealth District Attorney's Office trying to explain to the United States Attorney's Office why the United States Attorney's Office should step in and save their butts, right? That is that. I mean, I'm not a person that can break down any law mumbo jumbo. That's Melanie Little, Emily D. Baker. Um, oh, I love Lawyer Lee. She's really good. Who else? Andrea Burkhart, she's fantastic. So any of them that read this, they're going to understand exactly what's being said. Me, I'm just taking my what I think it means, and I could be dead wrong. So as long as y'all understand that, I think anybody can tell I'm not an expert. I'm just a very opinionated nana. Based on the collective experience of several of my colleagues, Massachusetts district attorneys, and former federal prosecutor, it appears to be unprecedented for the federal government to step into the middle of an ongoing state murder prosecution, prompted only by inflammatory and ethically dubious defense strategy. Now, don't quote me, but if I'm not mistaken, the FBI was already looking into these people. That's why this came on their radar, because these people will already be investigated for another reason. So that's how I see it anyway. In the conversation with the first assistant Norfolk District Attorney Lynn Beelan, Assistant United States Attorney Joshua Levy declined to identify what jurisdiction the federal government had in this murder case. Well, guess what, Morrissey? It's none ya. Okay? None ya. You see, you can't be trusted. None of y'all can be trusted. So you're only going to know things on a need to know basis. Comprehend need to know because you don't need to know anything because all you do is warn people and try to do cover ups. That's obvious. That's why these people are involved, right? I mean, they are of the United States of America. So, see, they represent the United States of America and judicial processes. They don't represent railroading an innocent woman. But you can tell right here, if you had nothing to hide, why would you care that this investigation was going on? Why would you care? Because if you had nothing going on, if you had nothing to hide, you could always think, oh my goodness, they're going to come up with something that's even bigger, better than what I have right here. That's what they're going to do. So by this, it just shows that, yeah, they're worried. They don't want anybody in their backyard. And, they're used to getting their way and used to getting along with what they want. So, I'm so sorry. Maybe I should just shush up and just read. Let's see. Oh, oh no. Oh no. Oh no. He didn't. Oh, listen to this. This is so disgusting. He's blaming them for everything they are doing. In what appears to be a highly unusual and possibly abusive exercise of power, Attorney Levy indicated that the U.S. Attorney's Office was still proceeding ahead with an investigation that would involve individuals who were active participants in events and/or witnesses in the case. Attorney Beeland reminded the AUSA Joshua Levy that any statements and/or testimony taken in such an investigation that pertain to any of the witnesses in the ongoing state murder trial may create an ongoing obligation for the state prosecutors to provide defense with access to all information and statements gathered or recorded as a result. He doesn't want them to receive any information that's helpful. Oh, I got you. As a result of the federal investigation, the United States Attorney's Office offered the opinion that you can't turn over information that you don't have. The position leaves state authorities potentially unable to meet the constitutional mandate expressed in Brady versus Maryland and the corresponding mass state rules. Since that call concluded, we have confirmed that witnesses have testified before the grand jury. Rule 6 of the Federal Rules of Criminal Procedure allows that under certain compelling circumstances, information may be provided to all counsel, including those not before the federal grand jury. Recent court filings and statements by defense counsel in the Reed matter suggest that the defense attorneys were the source of the initial complaint and the allegations prompting the action by the U.S. Attorney's Office. Oh, we're going to see the exhibit, and the exhibit is a report in the Boston Herald. So they're using the Boston Herald as proof. Wouldn't it be nice if we could use Turtle Boy as proof? Because he sure has all the evidence. I mean, come on now. All right, let's see. I'm sorry. I'm sorry. I just can't. Let's see the defense. Reed's defense counsel, recent court filings raise out of thin air and apparently purposeful misstatement of fact, unsupported claims of a cover up by investigators and witnesses, including municipal, state, and federal law enforcement, as shown in attached documents. Many or all of these unsupported allegations can be vetted and reviewed by the judges of the Mass Superior Court during the discovery and motion sessions or available appellate review. I am unaware and strongly doubt any prosecutor or state police misconduct in the Commonwealth versus Karen Reed. The only allegations to the effect that have been unsupported, news claims or defense filings that had not been answered at the time AUSA Levy confirmed the existence of the federal grand jury. It raises the question why the apparatus of the DOJ would intervene. Cameron Dwayne, turn the doorknob. Do not use the dog door. Who locked it? Okay, well, sorry. One child and two dogs so far. Just come in the doggy door. I'm so sorry. Yeah, if y'all want somebody who's not a squirrel, it's not me because I you never know what's going on in this house. All right, so let me go back. So I said which might explain these unprecedented proceedings. Let me read that again. Without dismissing the important role of DOJ in investigating allegations of police misconduct. Oh, I don't think I did read this. No, I don't think so. Sorry. This is me, y'all. Oh, barbecue. Okay. Without dismissing the important role of the DOJ in the investigating allegations of police misconduct and federal violations, we bring your attention we bring to your attention, my apologies, what appears to be additional concerns concerning motive, conflict or appearance of conflict, and potential bias by the Office of the United States Attorney for Massachusetts. Adam Lally. Adam Lally. Yeah, right. United States Attorney for Mass is yeah, Lally thinks y'all got some kind of prejudice. Okay. I predict the following information. Oh, I predicate the following information with the fact that it has been the policy of the Norfolk District Attorney's Office during my 12-year tenure as District Attorney to maintain a close working relationship with the United States Attorney for Mass. I'm not going to keep saying Massachusetts because, quite frankly, it's embarrassing that I stumble on that. And I've done it since I was a kid. It's not just, I mean, it's I guess a tongue twister for me or something. This is really interesting. And his 12-year tenure. I can imagine he had to work closely with the United States Attorney for Mass because this ain't their first rodeo at railroading somebody, is it? Notable in their relationship was the cooperation of the Norfolk District Attorney's Office in the prosecution of a 35-year-old murder case that was committed in Sharon, Mass, which involved the Whitey Bulger gang in the United States versus Flemmy. Okay, well, I don't even, whatever that was. I'm so sorry, my mouth was dry. Cool. The Norfolk District Attorney's Office had statutory jurisdiction to pursue the case, but in the interest of cooperation, acceded to the request of the United States Attorney at the time to allow federal prosecutors to proceed with the case. As a result of that agreement, the Norfolk District Attorney's Office and Mass State Police assigned to the Norfolk District Attorney's Office worked closely with the U.S. Attorney's Office on the case. Holy cow, so many words. During this period, AUSA Dustin Chao, without nexus to that prosecution, asked a Mass State police detective involved in the matter if he had any kind of damaging information on the district attorney first assistant or the Norfolk District Attorney's Office. Not sure what any of this has to. Oh, I guess this is trying to say why they shouldn't be involved, right? Mm. This susponte question was not without context. Laura G. Cheo, Dustin's wife, had been an employee of the Norfolk District Attorney Office prior to the case mentioned above. Not long into her tenure, it became apparent to her supervisors that she required more seasoning and legal experience if she were to succeed in a superior court role. She was offered the chance to gain more trial experience in the district court without any loss of compensation. Instead, she resigned and filed an ethics violation complaint with the Mass Board of Bar Overseers against the first assistant in the Norfolk District Attorney's Office. Well, shouldn't do that, right? The complaint before the bar board was it was summarized. Dismissed in order in short. Laura G. Chao was instead cited for violation of her ethical obligation to provide accurate address information for her practice long after separation. She was misrepresenting her address as the Norfolk DA's office. I began composing this letter well before the May 17th, 2023 publication of the DOJ Office of the Inspector General Report 23-071, which has apparently prompted the resignation of the current United States Attorney of the District of Mass. My attention is drawn to several portions of Section 2, particularly as they pertain to the weaponization of the U.S. Attorney's Office for personal, political, and retributive purposes. It says P46, I guess page 46, will regret the day he did this to you. Watch. P66, we asked Rollins whether her disclosure was retribution for the wrong she believed Hayden had committed. Page 69. Additionally, we determined that the days after Hayden prevailed in the September 6th primary election, Rollins sought to damage Hayden's reputation. P70. I'm guessing P70 is page 70. That's just my guess. I don't know. I'm probably the YouTube idiot trying to read this, right? But it's okay. I'm committed. I mean, I really want to know. I really want to know. Additionally, we determined that days after Hayden prevailed in the September 6th primary election, Rollins sought to damage Hayden's reputation. Page 70. The evidence demonstrated she used her position as a U.S. attorney in an ultimately unsuccessful effort to create the impression publicly that DOJ was or would be investigating Hayden for public corruption. If y'all notice that anytime anything is said in order to deal with the actual case, they just go off somewhere else. I mean, it's just amazing. They can't. They oh, these DOJ findings and questions reinforce my belief that the United States Attorney's Office for the District of Massachusetts must be removed from whatever investigation is being conducted into the Reed matter. Not sure about your thought process, dude. You got issues. I believe that a reasonable person could conclude that the same type of tactics are being employed against the Norfolk District Attorney's Office in the Reed investigation. The outgoing United States Attorney has made no secret of her personal animosity towards me, including repeated crude, outlandish, personal, and professional attacks against me in the media during her time as Suffolk District Attorney. See Exhibit E. I don't believe I have those, so. The head of the Public Corruption Unit has raised the spacer of personal retaliation for his wife's departure from the Norfolk District Attorney's Office. The public has the right to a U.S. Attorney's Office that is fair and unbiased as it executes its responsibilities. Morrissey, you might want to read that for yourself because your office was anything but fair. Your office was anything but unbiased when it comes to the Karen Reed trial. So you are just unreal. It's hard to believe that you can make these comments. It truly is because, no, just a little mishidden. All right. Weaponizing the United States Attorney's Office to conduct an unprecedented intervention into an open state murder case appears to raise the same concerns outlined in the DOJ's report. I submit that the pattern of using the USAO for personal purposes, established in Report 23-071, coupled with the obvious conflict of AU SA Chao, makes it impossible to conclude that a fair evaluation of unprecedented Reed intervention can be conducted by any party within the mass office. It's impossible to determine how far the tentacles of bias have spread out from the chief of the relevant unit and the titular head of the office. I know I said I was going to stop interrupting, but all right, Lally, take note. You and Morrissey, take note of what I just read. And then I want you to change that around because there is no way to determine how far the tentacles of bias have spread out in Canton, Mass. How's that? In Canton, Mass, including judges, the DAs, um, those that consider themselves the elite of the town. Yeah. Bias, I'd say you know what bias is. Tentacles, your tentacles should have been cut off years ago. But sadly, you're just allowed to just sit here and just do all this. I submit that the pattern of using the USAO for personal purposes established in Report 23-071, coupled with the obvious conflict of the AUSA make it impossible to conclude that a fair evaluation of the unprecedented Reed intervention can be conducted by any party within the mass office. Really? Because we feel it needs out of your hands, Morrissey. I mean, really? You don't think that the actual state could have handled this better? Anybody could have handled it better. Problem is, there needed to be some form of an investigation, and I'm not talking about blood in red Solo cups. It's impossible to determine. Did I just read that again? I just read that again. My apologies. I formally requested that an impartial federal official unaffiliated with the attorney's office for mass review and investigate the steps and actions that are being taken by current members of the mass office, exploring this apparent bias and when it's predisposed to them to abuse their prosecutorial discretion in this matter. In the unlikely case that an impartial review finds that the DOJ investigation into Karen Reed matter is appropriate, even before the issues at hand have been vetted by the Norfolk Superior Court judge hearing the case. This is in 2023, and I'm not hearing any evidence. I'm just hearing a lot of what we've heard the whole time. Flapping of the jaws. Let's just flap them jaws. I request that the investigation be reassigned from parties with clearly stated and documented bias against members of the Norfolk District Attorney entirely outside the office of the United States Attorney for Mass. Sincerely, Michael Morrissey, District Attorney for Norfolk District. This is from the U.S. Department of Justice, dated June 1, 2023. Dear Mr. Morrissey, the Office of Professional Responsibility, OPR, received your May 18, 2023 letter requesting that OPR investigate the decision by the United States Attorney's Office for the District of Mass, USAO, to subpoena individuals who are witnesses in your pending state prosecution, Commonwealth versus Reed. Give us a case number. To testify before the grand jury in ongoing federal investigation. You stated that the USAO's investigation is possibly an abusive exercise of power and likely based only on defendant Karen Reed's specious claims of witness and police misconduct, in addition to an investigation of the USAO's investigative, investigative. Oh my God, yeah, y'all. I did graduate high school. I really did. Oh, and I do help teach grandkids to read. That's some words, right? Decisions, you requested that the OPR transfer the USAO's pending investigation to another office without a history of conflict, bias, and abuse of prosecutorial discretion. OPR has jurisdiction to investigate allegations of misconduct involving Department of Justice, DOJ, attorneys that relate to the exercise of their authority to investigate, litigate, or provide legal advice, as well as allegations of misconduct by law enforcement personnel that are related to allegations of attorney misconduct within the jurisdiction of OPR. However, it is the policy of this office to refrain from investigating such issues or allegations if an active investigation is ongoing or litigation is pending. With regard to your request that another office be assigned to the pending grand jury investigation, a matter outside of OPR's jurisdiction, OPR forwarded your complaint to the Executive Office for the United States Attorney. That's EOUSA. For whatever action it deems appropriate. Further inquiry regarding that issue may be directed to the EOUSA General Counsel, J. Mackling. And they give his email. Thank you for advising OPR of your concerns. Sincerely, Jeffrey Ragsdale. Okay. Oh, thank you, Michael. Michael. Thank you. My son's name is Michael. So, if you're still here, I don't. Am I? Was it good? My kids know that my grandkids know I'm doing a video for YouTube, and kids, they're all obsessed with YouTube. So keep them away from the screen. All right. Oh Lord, Michael Morrissey again. Now he's writing to Joshua S. Levy. Dear First Assistant Levy, this is on May 9th, 2023. I'm probably only going to read one more, maybe. Well, we'll see how long they are. They're starting to get a little Yancey. If they all come in here, y'all won't hear me say anything. Dear First Assistant Levy, I write to follow up on our conversation regarding the issuance of federal grand jury subpoenas to at least two witnesses to the Commonwealth's investigation into the death of John O'Keefe. As you know, indictments have issued in Norfolk Superior Court and the prosecution is ongoing. As a prosecuting agency, the Norfolk District Attorney's Office has the constitutional duty to provide the defendant with exculpatory evidence. Y'all could care less about providing the defendant with anything. They had to fight tooth and nail to get anything from you. You took over a year sitting on evidence, over a year before you ever did anything with said evidence. Oh man, that's an on-board investigation. I would have had all those reports done back so fast your head be spinning. I would have moved this along really fast, really accurate. But I wouldn't have been chasing somebody who was innocent. So I guess there's that difference. Um, as you know, indictments have been issued in the Norfolk Superior Court and the prosecution is ongoing. See Commonwealth versus Karen Reed and gives a case number. Oh Lord, here we go again. As a prosecuting agency, the Norfolk District Attorney's Office has a constitutional duty to provide the defendant with exculpatory evidence, the obligation in mass to provide exculpatory information pursuant to Brady versus Maryland cites the case, and its progeny means not only the constitutional obligations to disclose exculpatory information, but also the broad obligation under our rules to disclose any facts that would tend to es- exculpate, sorry, the defendant or tend to diminish his or her culpability. In the matter of a grand jury investigation, 485 Mass, under the Mass Rules of Criminal Procedure, mandatory discovery includes all facts of an exculpatory nature and all the statements of witnesses. And then we're going to see all these. Okay. Oh my goodness. To effectuate our discovery obligations, we are requesting at the earliest possible opportunity discovery of all statements of witnesses to the investigation of the death of John O'Keefe and resulting prosecution, including both statements to investigate and grand jury minutes. The Commonwealth also has the duty at the time we become aware that statements of witnesses exist to notify the defendant of items under Rule 14 that the prosecutor knows to exist but are not within the care, custody, or control of the prosecution, and to provide all information known as to the item's location and identity of the persons possessing that item. Well, at this time, given the limited disclosure of information, this office is aware only that your investigation is likely to produce statements of witnesses through their grand jury testimony and through many interviews of them. Oh my goodness. Excuse me. My eyes, my eyes itch. Ugh. I've had a week. I had to go for my, what do you call it? Oh, Had to go for a lung function test. It wasn't the most pleasant in the world, but I'd made myself so sick with worry because I don't like doctors, hospitals, any of that, but it was all good. I did a lot of praying, listened to the lady, breathed till I thought I was gonna get dizzy. Alright, wait, let me take a fast drink. CMAS or Commonwealth Commonwealth versus Mitchell. That was in 2005, almost 20 years ago. We appreciate the sensitivity and need for discretion as to any ongoing federal investigation. While we are unaware of the perimeters of federal activity, we cannot forego our constitutional or state duties. We are willing to file a motion for a protective order under Mass R. Crim P to request limitation of the disclosure of the information to the defense counsel only. Why is that? Any decision of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or to request under Fed R. Crim. They listed for authorization from a federal district court judge for production of the grand jury minutes and related material, if any. So I guess they felt they needed to be able to see all the information, but not worry about giving it to the defense yet. Is that what it was? I could I could be understanding that wrong, but okay. Additionally, this office has constitutional and state obligations to provide exculpatory information of which we're aware in all cases, including exculpatory information relating to all witnesses and or members of the prosecution. Committee for Public Counsel Services versus Attorney General, 480 Mass. States pages. Commonwealth versus McFarland, 102 Mass. States that. Petitions for further appellate review pending. This would include any investigations into misconduct related to professional duties. If any such information exists, it's imperative that we learn of it in a timely manner. Sure, there's a lot of demanding. In sum, while we appreciate the notification that subpoenas issued, it is imperative that the earliest opportunity we are able to provide discovery to the defendant. First Assistant District Attorney. So if them asking for it for themselves isn't good enough, they're going to ask for it and say that, oh, they got to turn it over to the defendant. No, no, yeah. Okay, here we go. This is June 12th, 2023. U.S. Department of Justice Joshua S. Levy to Lynn Beelan. Dear First Assistant Beelan, thank you for your letter dated May 9, 2023. My apologies for the delay in responding, but I have been tied up with transition issues. We understand that your office has important discovery obligations in any criminal prosecution, and at this juncture, we have no issue with you advising defense counsel about the contact we have had with your office and the information we have shared if you determine such a disclosure is warranted under mass whatever. We are mindful of the important concerns raised in your letters and will be back in touch with you as circumstances dictate. Sincerely, Joshua Levy. Oh Lord, won't you bow me in Mercedes Benz? Here we go. We got Morrissey again. I wonder how much his house. The amount of money these people in law enforcement make too is just, oh my gosh, it's mind boggling. All right, so Commonwealth of Mass, Office of the District Attorney, Michael W. Morrissey, to Joshua S. Levy. Dear First Assistant Levy, this is to follow up on our previous communication. Making sure I haven't read this one. I don't think I did. Did I? No. Okay. I'm sorry. Wee, along for the ride. Woo, woo. All right. This is to follow up on our previous communication dated May 9, 2023, and your June 12, 2023 response on September 15, 2023. The Norfolk Superior Court set a trial date of March 12, 2024 in Commonwealth versus Karen Reed, and gives the number. On the indictments for second-degree murder, manslaughter, while operating under the influence and leaving the scene of personal injury and death. Under the Mass Rules of Criminal Procedure, mandatory discoveries include items of information within the Commonwealth's possession, custody, or control relevant to the case, including statements by the defendant, Karen Reed, statements of persons who testified before the grand jury, and grand jury minutes. Facts of an exculpatory matter, material and relevant, police reports, photographs, tangible objects, reports of physical examinations of any person, and significant tests and experiments, and statements of persons intended to be called as witnesses, and disclosure of promises, rewards, or indictments. Inducements, got to be indictments, made to witnesses the party intends to present at trial. Let's see, Mass Crim. The Commonwealth also has the duty to notify the defendant of items under Rule 14 that are known to exist but are not within its care, custody, or control, and to provide all information known as to the item's location and identity of the persons possessing that item. To effectuate our discovery obligations, we are requesting statements to investigators and grand jury minutes of witnesses in your investigation, as well as to the extent they may exist. Any of the other above described items and materials given in pending trial date, prompt disclosure is critically important. If there is a need for limited disclosure of such items, please include such a request. We are willing, with the appropriate foundation, to file a motion for protective order under Mass R. Crim to request limitation of the disclosure of the information to the defense counsel only, and decision of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or to a request under Fed R. Crim and sites for authorization from a federal district court judge for production of the grand jury minutes and related materials, if any, and discuss per that rule under what conditions the materials may be released for use in the state judicial proceedings. Additionally, this office has constitutional and state obligations to provide exculpatory information of which we are aware in all cases, including exculpatory information relating to all witnesses, and/or members of the prosecution. It lists Committee for Public Counsel Services versus Attorney General, 480 Mass. Pages. Commonwealth versus McFarland, 102 Mass. What they have to go. Petitions for further appellate review pending. This would include any investigations into the misconduct related to professional duties. If any such information exists, it is imperative that we learn of it in a timely manner. It is imperative at the earliest opportunity, we are able to provide discovery to the defendant if the investigation remains ongoing. We request notice of that status and information as to when the investigation may be concluded. In particular, whether the investigation is anticipated to conclude prior to March 24th trial date. Lynn Beelan. I don't know if I'm bugging, boring people to death or not, but this is interesting for me. All right, so this is from Michael Morrissey, November 22nd, 2023. Dear, this is the Federal Bureau of Investigation, Boston office, Jody Cohen, Special Agent in Charge. Dear SAC Cohen, it was a pleasure to meet you at the State House for the Governor's press conference on your hate crime enforcement. I wanted to again extend my welcome and best wishes to you in your role as the Boston Special Agent in Charge and look forward to working with you in the future. Also wanted to renew this office's offer for your agents to speak to the state police who were involved in the John O'Keefe Canton murder investigation. My first assistant district attorney also mentioned our willingness to talk to the FBI, to the acting U.S. attorney in a recent phone conversation. If you would like to have your investigators talk to the state police, they can contact Detective Brian Tully and they gave a phone number. Sincerely, Michael Morrissey. All right, I'm just going to say right there that I think he was trying to do some suck up, wouldn't you? And then I think that's the one I started with. No. Oh, did I read the June 1st? All right, here's Michael Morrissey, June 21st. I don't think I read this one yet. This is in response to June 1st, 2023, letter from the OPR regarding review of conflict of interest. Oh gosh. They spent a lot of time trying to get the FBI and the DOJ out of this case. Hmm. All right. Dear General Counsel Macklin, this letter is to inquire about the status of a request for a transfer of investigation due to a conflict of interest. I may have read this, but I'll read it again. On May 18th, 2023, the Office of Norfolk District Attorney sent to the Department of Justice Office of Professional Responsibility, OPR, a letter raising concerns as to a potential investigation by the United States Attorney Office for the District of Mass involving witnesses relating to a pending state criminal matter, Commonwealth versus Karen Reed, and the death of John O'Keefe in Canton, Mass. On January 29th, 2022. This office has subsequently received a June 1st, 2023 letter from Jeffrey R. Ragsdale, counsel for OPR, reflecting that to the extent that the letter indicated that the pending grand jury investigation should be reassigned to the appropriate office address that request was the Executive Office for United States of Attorney, EOUSA. This is to inquire about the status of this request and to provide contact information for any further information you may require. If you have any questions or you're looking for any additional information, I may be contacted as set out above. Okay, that's where they were asking them to basically recuse themselves. And then this one is the one I started with, basically where they were saying, nope, we're not going to do that. That's not what we're doing. We're not going to do that. Okay, so um, that's what it sounds like. So I'm amazed. They spent more time being concerned over the investigation that was going to involve these troopers, and they're having to testify. And they were, they weren't liking that very much. It seemed, didn't it? It seemed like they really did not like it. So with that, folks, what I'm going to do is I know that I am green to say the least when it comes to even knowing what I'm doing on here, but I just wanted to share this. I know that there's times I wish this was out so I could just listen to it, just put my earbud in and walk around listening to everything. And I wanted to read it. Sometimes I think maybe I might retain more when I read it out loud. At this stage in life, I don't know what I retain more of. I'll go, "Oh, yeah," and then I can't remember. So that's why I'm reading them here. And for anybody that stops in, I so appreciate it. I'm not sure what I'm fixing to read next. I'm gonna check. I know that got some orders to do them in, but I've got other items that I'm gonna read, and other videos that I'm gonna share. Hi, MD, and hopefully it will be informative because so far what I'm seeing right here is it's just more of them trying to cover up what they're doing, you know? And I just have to add this, the people that testified, the McAlberts, the non-law enforcement people, that um, the elite in Canton. And mind you, they're only elite in their own minds. Nobody in Canton thinks of them as elite. Aw, thank you, dirt in my eye. So the thing that gets me about them is their concern is covering their own behinds. And they have why in the world, if they if they've done nothing wrong, if they have nothing to hide, why does everybody have their own attorney? I mean, I'm surprised, to be honest with you, that Brian Albert and Brian Higgins. I don't remember. Oh, and Jennifer McCabe. I'm surprised each butt cheek doesn't have an attorney. That's who needs the attorney. Those butt cheeks have been abused. They've been lied about. They've been abused. Nobody seems to care about the butt cheeks. All I know is my butt cheeks would be safe from any text messages from any of those elitists. That's what I can say. So I'm going to leave the thought of the butt cheeks needing good attorneys for what's coming up next to them, because the next time the defense, if they keep pushing this, if the FBI doesn't step in and just obliterate the Commonwealth's accusations, because really that's all it is. It's accusations. Um, the defense is going to be one to reckon with at the next trial. If they have to go to trial again, Lally, you didn't see anything yet. And if we have to listen to Lally sit up there and ask who drank what, when, and where, if somebody doesn't rein his behind in and to focus on the case, if we were to have only focused on the case, really wouldn't have been that long of a trial. We had to listen to everybody, and he had to call everybody because he was so afraid. Good job. He was so afraid that something was going to come out. You see, Karen Reed has no fear. To me, and of course, none of the jurors even knew this. None of the jurors were allowed to even know that the defense attorneys were not allowed. Now, if I'm not mistaken, it was was it Judge Bev, or was it the people for the FBI? I don't know, but I think it was Judge Bev. They couldn't speak to these experts. That's right. They weren't allowed to talk to the experts. And so when um, Alan Jackson did the argument or was talking about the experts, and they had to have a voir dire, and the judge is like, "Well, you should ask this and that." I mean, I'm sure. And did you notice that? Because basically, she was calling him a liar. I took a big offense to that. Big offense, huge. When she goes, "Well, I would assume that the defense would want a crack at him or something like that, if in fact you have not spoken to them." Something along those lines. How dare she? Because I don't really think that their integrity has been brought into question. We've had Trooper Proctor get up on the stand and actually lie about a situation, saying that it happened, that it never did, and David Yannetti was in shock over that. I mean, you could I mean, he literally, you could watch it in the courtroom. He didn't know what he was talking about. And after court, when he said that he just he just watched Trooper Proctor commit perjury, and he made it up as he went. That was that's what we have with this case. So I'm not real sure how we're supposed to just sit around. Sorry, to get my house shoes. Sit around and act like they're great, because they're not. There is something so very wrong with what's happening here. So, since Beverly wanted to not be concerned about the jury and the fact that they reached out to everyone, and I tend to believe that when they reached out to the attorneys and the defense, they also reached out to the Commonwealth at the same time. So when the Commonwealth, when Lally stood up there and made those remarks, such smart ass remarks, snarky, it was so snarky, about not believing it and over the top or whatever he said. I mean, are these people held to anything ethical? Because to me, that's so unethical. He had been reached out to too. He just didn't answer. And by answering doesn't mean that you're asking them to tell them about the deliberation. It just means that you're listening to a juror who does in fact have the right to reach out to attorneys. They have the right to reach out to to anybody. They have the right to call the governor if they want to. It's just sad that Beverly is putting every juror through this, because this doesn't stop for them. It doesn't stop for them. They're screaming from the top of their lungs that she was found not guilty. Counts 1 and 3. Beverly, not good enough for her. And Beverly's, her little thing about Alan and Yannetti never needing a chance. Let me tell you something. By the time she walked up, read that, said, I'm not going to put you through that. I'm declaring a mistrial, and I will meet you in the da 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 room. I'll be in there to talk with you. And then turns and as soon as they're out, starts discussing scheduling. Where were David Yannetti or Alan Jackson supposed to actually have stood up and said, "Whoa! Hold up, hold up. You can't just declare a mistrial. You need to check with them. Did they have any verdicts on anything? Did they come to any agreement on anything?" What do you think Beverly would have done? She may have heard them, but what do you think it would have done? The only thing that it would have done is looked a whole lot better for the defense in this because she would have still ruled the same way she ruled. Nobody can doubt that. She's the most disgusting judge I've ever seen. She's absolutely disgusts me. I have absolutely no respect for her. If she's the only judge on the bench, I no, I ain't going in front of her. You couldn't pay me to go in front of her. So, with that, I'm going to say bye. I'm going to go get me some coffee. My husband's been home quite a while, and I need to say hi to him. And I'm not sure what I'll do next. But believe me, I have lots of stuff in here. I just have to figure out the order. But the reason that I wanted to read this today is because all of these emails go along with the change in Karen Reed's profile picture. And I'm just having a hard time believing just how dirty the DA in Canton is. Because I mean, he's smothered in as if he would have been tossed in the swine bucket to get him prepared for something. So I don't know. So I'm going to say bye. I thank you all so much for stopping by and you enjoy your night. Well, enjoy your weekend. I don't know if everybody's back in school, but my grandbabies are back in school. We just had our second week of school. So weekends now actually mean something. Weekends, enjoy yourself. But I'll be back and hopefully one day I'll be better too. So, bye everybody. Oh, before I forget, please go to the Crap Goth and Crack in the Box on YouTube. Give them a like and a share. Subscribe to them. If you're interested in just absolutely heartwarming little boy and his channel, he's he's our angel now, but his channel will want to keep alive forever. And um, his mom's brilliant, and tomorrow he actually is the second year that he has had his birthday in heaven, and he would be 13. And 13-year-olds are so fun, aren't they? Ha ha. Yeah, I love picking on them when they're teenagers. And he he'd have been a, as he liked to say, bloody brilliant teenager. So um, give him a stop, give him a shout. If you know anybody that will like their content, please share it. It means a lot. So y'all have a good night. Bye.